Now, let's now move across to a big news that's coming in from the world of business, because it's a big blow to the center and mining companies and a victory for mineral-rich states. The Supreme Court has ruled that the states can now collect past dues on royalty on minerals-bearing land from the center. Now, Rajat Mishra and also Priyanka Das from the Republic Business bring us all the details as far as this is concerned.
Thanks. I have my colleague Rajat with me, and let's get the details from this Supreme Court ruling, which is going to impact not only the minerals but also all the mining companies across the country. So Rajat, tell me what does this ruling mean, and could you also explain what the retrospective tax is all about?
So yeah, Priyanka, this is the biggest ruling the entire mineral sector was looking up to, and a 9-judge bench of Constitutional Bench of Supreme Court has come out with a verdict, and they have rejected the center plea, saying that they will not accept the submission of the central government to not go for retrospective taxation, and they upheld the right of the state governments to go for taxes under the Mines and Mineral Development Regulation Act. So what does this mean? So I will just take you through the entire journey. So on 25th of July, Supreme Court also upheld that this can be implemented retrospectively, while the center was against this argument, and they said that all taxes should be applicable prospectively. But the Supreme Court now has rejected that plea and said that we will go for the retrospective taxation, and they have drawn a distinction between royalty and tax, and they are trying to give an impression that royalty is not a tax and they are two segregated things. So that in itself overturns the judgment of India Cement versus State of Tamil Nadu, on which the entire previous judgments were based. So in 1989, India Cement went to Supreme Court when Tamil Nadu government was trying to levy a cess on the royalty. At that time, Supreme Court said that royalty is in itself a cess, so there cannot be different tax. So this time they have overturned the India Cement judgment, and they said that royalty is not a tax, and states have the power to levy the taxation, and that's a win-win for the state governments. And also Supreme Court Chief Justice Chandrachud has said that no interest and penalties will be levied on this, and they have decided a cutoff of April 1, 2005 for this calculation of the taxes that the state government have to collect from the mineral companies. So that will start from April 1, 2005. In a bid to provide the relief to the mineral companies, they have said that the payment from the companies will be staggered over 12 years in an installment to the state. That will start from April 1, 2026. So that is also a big relief for the mineral companies. Second big aspect of the ruling is that no penalty or interest calculation will happen. That is also a relief. But also we have to understand the center, when filed the plea, said that this will have a financial implication of 70,000 to 80,000 crores. And today in itself, Federation of Industries and Minerals has come up with a statement that this will have a financial implication for the mineral companies in tune to 1 to 2 lakh crore, which is huge. So the cutoff has been decided on the premise of Kasoram judgment versus State of West Bengal. The big takeaway is India Cement versus State of Tamil Nadu has been overturned. Taxes will be applicable from April 1, 2005. No interest and penalties will be levied, and this will be staggered in a 12 years installments to the state governments.
Right, Rajat. Thank you so much for the details. Over to the studio.